Thank you very much, Madam Chair. I want to pick up where that last question left off. One of the issues that you talked about in your opening remarks was about access to justice. And we have seen all across our courts, civil and criminal at every level, a huge rise in self-representing litigants. Sometimes those people are vexatious, but in a lot of cases, it's because they simply can't afford representation. And self-represented litigants cause delays that have a domino effect all through the system. So I wondered if you could speak first about how you handled self-reps in your previous court work in Manitoba, and what you think the Supreme Court has to do to deal with the increasing number of self-represented litigants who are appealing to the Supreme Court and taking up time on your docket.
Well, I won't speak to what the Supreme Court of Canada has to do, except indirectly. I mean, I don't know the situation as well as I should to answer your question. They are dealing with, I think, increasing numbers of self-reps, particularly with leave applications. But I'll just put that aside and maybe deal with what I can speak more directly to. Self-representative individuals represent a real symbol for how our system has evolved in ways that I think represent imperfections in how we are able to address litigants in Canada. The system isn't imperfect because we have self-represented individuals, but it tells us something about the complexity of Canadian society. There's socioeconomic pressures that are obviously bearing upon individuals that keep them from being able to hire lawyers in many instances. And when they come to our court, they present particular challenges because they want justice and they want to be able to interact with the courts in a human and ideally informed way so that it can help us, so that we can help them. The challenge for judges is enormous, and it's not a new challenge. We've been actually addressing the challenge of self-representative individuals for probably over 10, maybe even 15 years now, and we're constantly evolving our approach. But there are National Judicial Institute courses on self-represented individuals. There's ways that try to teach us methods by which we can more humanly interact with them in a way that doesn't cause us to skew the balance, for example, of an adjudication where on the other side the litigant might have a lawyer. We can't compensate to the point where we're creating an imbalance. So we have to find a way to thread that complicated needle. And it's not easy to do, and it's really case by case by case by case. And I think, you know, over time we've received guidelines, we've seen directives from appellate courts about what has to happen, what the minimal flooring is in some instances, with respect to how judges have to ensure that certain information is provided. So all that is helpful. But I'd be pretending, I think, Senator, if I said we have easy answers. It's an ongoing problem. Part of it's a socioeconomic problem, part of it's a societal problem, and part of it's now a legal and judicial problem. So we're doing the best we can to try to be fair and to make sure that even individuals who are representing themselves aren't denied access and hopefully not justice.
And if I've got time for a follow-up question. We've talked
20
about
seconds,
the people
Senator, yeah.
All right. What do we do then about the vexatious litigants, the freemen on the land, the people who have lost trust in the court system? And that's also a part of the self-rep problem.
That's a complicated issue because there may be many reasons why they've lost trust. If they've lost trust for reasons that relate to things that we can control, then we have to do better. And there's obviously clear and strict tests for designating someone as a vexatious litigant. We don't want to sort of contemptuously, and you're not doing that, but judges certainly don't want to sort of marginalize somebody as vexatious just because they're noisy or because they're difficult. There is a particular sort of test that has to be applied. But there are some individuals who are self-representative litigants who aren't particularly interested in the justice system as we know it. They're interested in making a different point. And while we have to address them, I put them in an entirely different category than those self-representative individuals who appear in good faith and are appearing by themselves for reasons that really are no fault of their own.
Thank you very much. Merci.